Hey, everybody. Ben Wittes here. Welcome to this week's Trump Trials and Tribulations, which may as well be called Lawfare's Trials and Tribulations, because it has been, this week has been an ordeal. Let me start by apologizing to everybody for the technical disaster of yesterday. And let me also say that these things are highly improvisational. And as you all know, we are doing this by the seat of our pants. And the seat of our pants sometimes gives you a wedgie. And so that's what happened yesterday. So today we have reverted to a different technical setup. I am here with Anna Bauer in the Lawfare Content House, but in different rooms of the Lawfare Content House because, that whole doing a studio in one room thing, that still needs a little bit of work. Roger Parloff is joining us from the Scott studio. Quinta Jurecic is joining us from the Brookings Institution with the Endless Scream pillow in the background. And we're going to get right into it. So we're going to start with the thing you're least expecting us to start with. And we're doing this for two reasons. One is comprehensiveness, because on Lawfare Trials and Trump Trials and Tribulations, we actually want to cover the full range of this litigation, not just what's hot today. For those of you who really want to talk New York, we're going to do that a little bit later in the show. But we have some new state-level criminal prosecutions going on. And I asked the estimable Quinta Jurecic to gobble them up so that she can feed them to us like baby birds. So Quinta, give us the lowdown on Arizona.
Yikes. So I will say we have a piece in Lawfare, which we can put in the chat, on that we published on April 23rd, that gives an overview of the range of prosecutions at the state level of the fake elector plot. So there are 7 states in which there were fake electors: Michigan, Wisconsin, Pennsylvania, Nevada, New Mexico, Georgia, and Arizona. And we basically took a look through at what the legal proceedings have looked like in all those states. Of course, Georgia is the most famous, I think it's fair to say, indictment. The Georgia indictment did involve some of the fake electors plot, but there has been criminal process in other states as well. So in Michigan, folks may be aware, there was an indictment that was handed down, I am not quite sure when, but in the last year or so, that indicted a number of folks involved in the fake elector scheme. Recently, we actually learned over the last week from testimony that's been taking place in some of the preliminary hearings in that case, that Trump, the Michigan Attorney General's office, considers Trump to be an unindicted co-conspirator in that case. And we also now have an indictment in Arizona, which appeared the other weeks. And this was an exciting one because so far, the Georgia indictment was the only one that had focused sort of beyond the boundaries of the state itself, to look at, conduct in the White House in Trump's immediate vicinity. The Michigan indictment, until we learned this news about Trump as an unindicted co-conspirator, really has confined itself more to the actions of the fake electors in the state itself. And there was also a Nevada indictment that came through recently that, again, was focused very narrowly on the fake electors in that state. But Arizona is a lot more sprawling. I don't think it's quite as sprawling as the Georgia indictment, but it is a bit more expansive. So it indicts the Arizona fake electors, including former Arizona GOP chairman Kelly Ward, who may sound familiar, a number of other folks who are sort of prominent in the Arizona Republican Party, but also indicted a number of Trump associates. So initially, their names were redacted because they had not yet been served. Journalists have been able to figure out pretty easily who they are, though. And so, according to reports, the additional indictees are Christina Bobb, who is amusingly currently the RNC's senior counsel for election integrity. Listeners may also be familiar with her. I believe she showed up early on in the Mar-a-Lago case. Roger, correct me if I'm wrong. Yeah, so sort of an expanded Trump universe cast of characters here. We also have John Eastman, Boris Epstein, both of whom were identified, or we believe Boris Epstein, certainly John Eastman, were listed in the federal January 6th indictment as unindicted co-conspirators, although they were not identified. We also had Jenna Ellis and Mike Roman. The last two were indicted in Georgia as well. And then, of course, last but not least, Rudy Giuliani and Mark Meadows. And then there's also a number of unindicted co-conspirators listed, chief among whom is Donald Trump. And also, interestingly, Kenneth Chesebro, everyone's favorite cooperating witness. Since he pleaded guilty in the Georgia case, he's been going on kind of a grand tour of all of these state investigations. And one of the things that we found in our write-up is that again and again, if you read news reports, you see that Chesebro shows up as a cooperating witness, someone who was, extremely forthcoming before the grand jury, gave prosecutors a lot of information. And so I do wonder if one of the reasons that he shows up here as an unindicted co-conspirator is essentially because he was cooperating with prosecutors and really helping them out here.
All right. So question, which is what is the unique work, if any, that the Arizona case is doing over and above, say, the Michigan case and the Georgia case? I mean, the Georgia case has some unique stuff in it, like that they indicted Trump himself, and there's the whole RICO element to it. The Michigan case seems very narrow. It's kind of fake electors, and that's it. What is there any work that the Arizona case, which I have not yet read, is doing that is not duplicative of some other state? Which, by the way, it's fine if each state has its own equities in these cases, and so there's nothing really wrong with cases that are largely duplicative of one another. But there's something very interesting about when states bring something really new to the table. Is there anything? I mean, Boris Epstein is new. Kelly Ward is new. What's distinctive about the Arizona?
Christina Bobb.
Right. Mm-hmm. What's distinctive about the Arizona case beyond that?
I think that is really what's distinctive. I mean, one of the things looking at this indictment alongside the other indictments that have been released in these other jurisdictions and ongoing criminal investigations. So I believe there is currently an ongoing criminal investigation in Wisconsin, which took a while to get going, but is now moving. There is a duplicative quality, right? Particularly if you read them alongside the Georgia indictment and the federal January 6th indictment. They're all describing the same sort of bucket of conduct, which is this effort to put together fake slates of electors and transport that to the National Archives and to Mike Pence. And you see some distinctions among states as to how that was done in ways that end up being very important. So in Pennsylvania and I believe in New Mexico, there's qualifying language in the fake certificate that essentially says we're doing this just because we might later be determined to be the duly qualified electors. And in both Pennsylvania and New Mexico, the respective attorney generals of those states essentially said, look, we don't think we can prosecute this because that kind of negates the potential criminal intent. Interestingly, in New Mexico, the attorney general actually proposed criminal legislation that would allow prosecuting that case anyway. I think that there was legislation introduced that I believe has now stalled out in the New Mexico legislature. Pennsylvania basically said, we're just not going to move forward with this. But
yeah, I gotta say, I gotta say, I think if you clearly label what you're doing as fake electors, right? If you have a bunch of fake electoral certificates that say basically on them, no warning, fake electors here. I think that's First Amendment free speech, and I don't think that should be illegal. And by the way, that gets awfully close to the situation in Hawaii in 1960, where the role of alternative electors was entirely legitimate. I think the problem with what the Trump people did in this campaign was not that they set up alternative slates of electors, but that they misrepresented it and sent them to the National Archive. And so I got to say, I don't really think there's anything wrong with an alternative electors scheme. Am I being too soft?
I have not looked at the legislation that was proposed by New Mexico Attorney General Torres. I put this on the table. If it is passed, I am sure someone will challenge it on First Amendment grounds. I mean, I do think that gets to something important, though, which is like, as we have all been learning when it comes to the New York criminal case, state law is weird. One of the things that you learn looking at these different indictments is there are like kind of weird state laws. So in the Georgia indictment, of course, we had that strange charge that had to do with violation of the oath, which, Anna, correct me if I'm wrong, I believe Judge McAfee tossed out, correct?
I'm sorry, I was looking
the violation of the oath of office charge.
Yes. Mm-hmm.
So that is a Georgia statute. I do not know of any comparable statute on any other state, and you don't see that charge. Michigan has this weird charge that's something called uttering and publishing, which
sounds like bad news for lawfare.
Exactly, but it has to
we do a lot of uttering and publishing.
But it has to do with forgery. New Mexico, for example, one of the things that Attorney General Torres pointed to in his final report is that New Mexico doesn't have laws that criminalize the submission of election documents and impersonating public officers in the way that Michigan and Georgia do. So just states have different sets of tools in the toolbox. And so I think the interesting thing to me in looking at these different prosecutions is less, what new information we learn, because frankly, the fact pattern is pretty much the same everywhere. There might be some things around the margins, but there's not a huge amount of new information. So far, that could change. And more kind of seeing how different state law enforcement agencies use the different tools available at the state level to bring these prosecutions, which is, the magic of federalism, I suppose. And also, I think there's something important to it, particularly in light of the fact that, frankly, Trump is running for president again. And the fact that, we have these state governments, some of which are in states that, may well remain blue, that are showing that they are interested in prosecuting this kind of election chicanery. And, even if Trump is in charge of the Justice Department and can shut down any kind of federal investigation into that kind of activity, he has no power over the Michigan Attorney General or the New Mexico Attorney General. And so I do think there is kind of a powerful a sort of backstop effect here in having all of these different state investigations. I should also say, because I do think it's important, there's a way you could frame what I just said as a kind of, how dare they get two bites at the apple? This is a double jeopardy problem, right? I don't think it is for a variety of reasons. But one of them is that, it is totally legitimate for a state to be concerned about people trying to, interfere with the transfer of electoral votes from that state. The federal government is concerned about that. But, of course, the state of Michigan should be worried about people falsely representing themselves as electors from that state.
Yes, I just want to say, sorry, go ahead, Roger.
Just to Ben's point, I just want to say, Jack Smith in the indictment in DC sort of says what Ben says, that, some of these electors were acting legitimately and they were themselves victims. They were tricked. And also that sometimes the theory evolved from a legitimate theory into a criminal theory. So, Jack Smith recognizes what Ben is saying.
So I just want to say on the duplicative point, I think the word duplicative was hasty on my part. A serial killer who goes from state to state, and we would not say the charges are duplicative. That's the nature of serial offense, or in this case, concurrent offense. And there are no double jeopardy problems associated with multiple charges by different sovereigns. And so the issue here is not one of duplication in any legal sense. It's really just more, does it feel like the same stuff that we've already seen indicted? And obviously every state has the right to enforce that itself. But from an intellectual point of view, if you're saying, okay, what's new in Arizona, the fact that they've indicted a bunch of state electors for a state elector scheme is, not new or surprising. All right. So anything else on state level fake electors stuff?
That's really the gist of it. I will just say I'm going to be really interested to see how this plays out going forward. In particular, whether Arizona tries to take the next step in actually indicting Trump. In Michigan, we've had this indictment out there for a while at this point. I think someone helpfully pointed out in the chat that it was handed up in July 2023. So, it's not impossible that they're still investigating Trump. We haven't seen any indication of it. I would be interested to see if, this Arizona indictment is kind of the opening salvo, and the attorney general decides to actually go forward with indicting Trump, and particularly because I don't know enough about Arizona politics to have a clear sense of how this would go, but you can tell a story where politically, that could be advantageous or disadvantageous in some way. So I think it's worth keeping an eye on. Oh, and I should also say there's an ongoing investigation in Wisconsin. It took a while to get started, but there has been reporting that, again, Chesborough is cooperating, that the Wisconsin Attorney General's office is investigating, and we will see if that does end up moving forward.
All right. From the state of Arizona in all its dry dustiness and beautiful desert vistas to Fort Pierce, Florida, however you want to characterize it. Let's talk about the latest in the fastest moving, slowest moving case in the world. There has been a flurry of action on the part of Eileen Cannon. Roger, is it moving forward, or is it a flurry of action running in place, or even skipping backwards?
Well, it's sort of moving forward. She's unsealing, unredacting lots and lots of stuff. That's obviously in preparation for holding hearings on lots of stuff. But there are some mysteries as well. Formally, this case is supposed to start in less than 3 weeks. We're still set for trial on May 20th. We're supposed to have a...
I think Justice Merchan might have something to say about that.
Yeah. There's some, there's a Section 5 notice that I've mentioned before that's an important turning point. That's supposed to happen in 8 days on May 9th. Trump has said, I can't do that because I'm on trial in New York, and the special counsel has objected because the judge knew about the trial when she set this date. All of that's been fully briefed for 2 weeks. We don't know what's happening there. There has been occasion where she sort of rules by passive aggression. She fails to rule, and then as she sort of plays chicken with the attorneys as they approach the deadline. She did this once with the special counsel, and they caved because they knew that she would hold her in. She would hold them in contempt if she didn't meet the deadline. I don't know if she's doing that to Trump, but I sort of doubt it. I think we'll eventually get a ruling. So anyway, she has she's in the process of unsealing lots and lots of things, she's protecting the name, but basically only the name. And this means that a lot of these witnesses are really identifiable at this point. And that puts some of us in a funny position, but I think it's obvious the judge has ruled this is public, and the special counsel has failed to take her up to the 11th Circuit. And I think we, need to report on what's there. But you do have this strange thing where, what happens with Jenks material, stuff that's usually secret, is, people are frank in their FBI interviews. They don't think these are going to be public. And so you'll have, person 16 will say person 5 is a complete moron. Person 16 says person 24 is unhinged and crazy. And we basically know who person 24 is. And it's not Sidney Powell, by the way. But so there's all of these things. And we are learning more about the case. What we're going to get now is a lot of the Trump's motions that are and NOTAs based on alleged selective and vindictive prosecution and on prosecutorial misconduct. And of course, these motions really play into Trump's campaign themes that I'm persecuted, you would never be doing this to another president. And they would like to hold hearings on these questions over 3 days between July 1st and July 3rd. Well, that happens to be less than 2 weeks before the Republican convention. So, they want to get out all of these sort of talking points. And it could be that that's where we're going. One other thing that has, you might remember at the time of Trump's indictment, there was a flurry of stuff about a flap involving Woodward and whether a prosecutor had sort of mentioned that he knew that Woodward had been nominated for a judgeship, and gee, it would be a shame if something happened to that golden opportunity for you, and things might be better if your client flipped. Obviously, we've gotten now that whole saga, all of that briefing has become unsealed in the last week, and we know at least the government's view. Obviously, the government's view is it didn't happen. They didn't know. They did bring up. They thought that they didn't know who Stanley Woodward was. They looked him up online and they saw. If you go to Google and you click on Stanley Woodward, you'll see a thing that says something about nominating committee. They clicked on nominating committee and they thought that he was on the nominating committee. And they told him, as a professional thing, congratulations, you're on, that we noticed you're on the nominating committee. And then Woodward corrected them and said, no, I'm not on the committee. I'm actually a nominee. And obviously they claim that they never in a million years, and it would be, it would be odd for a 30-year veteran of the Justice Department in the presence of 3 other federal prosecutors to, try to extort and bribe and intimidate the opposing counsel in this way. So, it's and nothing was said about this incident for 9 months, but this happened in August 2022, and nobody said anything until they got their target letters. And then, 3 days before the indictment came down, Trump's lawyers made this accusation. And in the context of trying to stall and, we'd like more material. And then Woodward did confirm in a letter, essentially confirmed that his view that this is what had happened. And he wanted the OPR, Office of Professional Responsibility, to investigate it. And he wanted an indictment to be postponed until OPR had made an assessment. So it was all in the context of delay, which further, draws into question. But in any event, it's not a great thing for this special counsel. And the person who's the fact finder is Eileen Cannon. So, this is not a great thing either. And it is a factual dispute, which seems to justify an evidentiary hearing. And you got to wonder, where are we going? Are we going to have, Jay Bratt on the stand, and then the other 3 prosecutors that were in on the call? I mean, none of these people have yet filed any affidavits, including Woodward. He submitted a letter, and the other 3 just signed briefs. So it's not a great thing, but that's.
And it has a very Fulton County
it does.
feel to it.
It is very Fulton County. Yeah.
If you exclude there's no sex involved in it, and but there's this idea that you can effectively defend the client by creating or alleging with whatever degree. You can't have no truth to it, because then you become sanctionable for a frivolous filing. But you find some read of truth, which in Fulton County turned out to be a bit more than a read. But you find something to create what's essentially a collateral attack on the prosecution in the form of the alleged ethical misconduct of the prosecutors. And it's a very old tactic, but it's interesting that it is now showing up in 2 of the 4 major cases here.
Yeah, and there's no sex in it, but in 2 respects, it's sort of worse for the government in that one, well, I maybe this isn't worse for the government, but it really fits with all of Trump's campaign points. I'm persecuted. This is selective, vindictive. The other big difference, and it does. This does favor Trump, is the judge, who is really receptive to any hint that the special counsel did anything wrong. She is not only receptive, she has initiated, explorations. She has told them, without them, sua sponte, on her own, she says, "What I want you to tell me what's going on. Was the DC grand jury abused? Are they abusing the DC grand jury when I've got the case? And what happened there?" And in fact, even the Stanley Woodward stuff, 2 months after this was first reported in The Guardian, I think Hugo Lowell was the first to report this mess. She, on her own, issues a then sealed order to the parties. I want to know everything that happened about that in my independent, in my role as independent monitor of, the integrity of these proceedings. So she, on her own, really explored, and so these are not great signs for the special counsel.
Well, it's been a while, Roger, since you saw a great sign for the special counsel in the Southern District of Florida.
Yeah, or anywhere else.
Well, I don't know. I mean,
okay.
As one wag said to me, wandering out of the courthouse the other day in New York, this looks like it's the only game in town. So let's, and the thing that prompted that wag to say that was that we were all sort of watching the proceedings with one eye and watching not our phones, because that brings down the wrath of the New York court police on you, but watching our streams on our computer for information about the Supreme Court oral argument on Thursday in the immunity case. So let's talk about that. I watched it after I watched everybody. I listened to it after I watched everybody panicking about it. And I gotta say, I thought it was a much less bad argument than I would have thought from the panics that I was reading contemporaneously with it being described. And while it was taking place, and I was heartened by the superb discussion that you all had about it the next morning on the Lawfare Podcast. But let me start by fleshing out or describing how I read the argument, and then Quinta and Roger, tell me why I am a ray of sunshine in the face of the perfect storm that is going to swamp our little boat. So first of all, I was not at all surprised to see that there was a group of justices who are concerned about the clear statement rule issue. I've been saying since Quinta and I wrote a piece about it, actually since before that, Quinta and I wrote a piece about this briefing at the district court level, and I wrote an earlier one with Sarafin Dhanani before the motion was even filed. Here's what we can expect, saying that like this is actually a serious issue, and that there is no absolute immunity is an easy issue, but how you craft the ways in which the law affects the presidency differently from other institutions and other individuals is actually super tricky. And so I looked and I said, okay, maybe Clarence Thomas is into the absolute immunity thing, but even Justice Alito, confronted with Mr. Sauer, described him as taking an extreme position, didn't seem into the absolute immunity argument. Moreover, I thought Amy Coney Barrett sounded very thoughtful and careful on the subject of how you would read the statutes in question. And the Chief Justice, who clearly has a problem with the DC Circuit ruling, did not seem to me to be gunning for the principle that, although Brett Kavanaugh kind of did, but the Chief Justice didn't seem to be gunning for the principle that any statute that doesn't name the president specifically doesn't cover him at all. And so I looked at it. Oh, and then Amy Coney Barrett elicited from Sauer a pretty candid admission that a huge range of the acts described in the indictment aren't official acts anyway. And so I was left with I don't want to say sanguine, because the Supreme Court's capacity to disappoint me is legion. But I would say not panicked, sense that there are almost certainly 5 votes for something reasonable, which is not to say, affirmance of the DC Circuit in its entirety, but an opinion that will let the body of this case go forward. And the only real question in my mind is timing. And so, Quinta, Roger, how am I wrong?
I don't think I disagree with you on the substance of what you just said. I think my main disagreement is on that last point about timing, because timing is kind of the whole ballgame here. And I was struck throughout oral arguments how the court seemed to drift away from the facts at issue in this specific case, and kind of move toward, hypotheticals, how this might play out down the line, reading big chunks of Scalia's Morrison dissent for some reason, sort of thinking about much bigger issues, which I think connects to Justice Gorsuch's stated desire to settle this issue for the ages, as he said, rather than just confining themselves to the case in front of them, which normally we would call judicial restraint, and conservatives would be a big fan of it. And I found that frustrating because it speaks to an almost perverse unwillingness to imagine what is right in front of everyone's eyes, which is the longer that the court takes to think through these issues, the more likely it is that this case does not go to trial before the election. You can make an argument, and I think Jack Goldsmith has set out this view very capably on Lawfare, that, such considerations are not appropriate for the court to consider. The point where I think I diverge is that, throughout oral argument, the justices were not, this was not a situation where they were saying, fiat justitia ruat coelum, right? Let justice be done though the heavens fall. It's our job to think only about, the high principles and let the chips fall where they may. You guys pick up the pieces afterward. They were very alive to the potential practical consequences of a ruling in one direction or the other, which is how you got these kind of wacky hypotheticals from, Justice Gorsuch saying like, but what if presidents started always pardoning themselves? Alito having this kind of bizarre suggestion of, but what if the president was incentivized to try to illegally hold on to power? That there really is they're conscious of how what they do here will create perhaps unintended incentives for presidents going forward. And so it strikes me as willfully averting their eyes, to focus on that, but then ignore, as kind of a matter of, politeness, essentially, the obvious practical consequences from the question of how long it takes them to get a ruling and what the kind of procedural disposition of the ruling is if they kick it back. So we end up having a ton more pretrial litigation, or whether they just send it back to Judge Chutkan saying like, okay, get on it, you can figure out these immunity issues through evidentiary rulings. Now, you could argue that those are different, you could draw a distinction between those different considerations, but I frankly found it, the more I think about oral arguments, the more frustrating I found it that the justices were unwilling to confront that head on. And by the way, like, I'm not being partisan here. This is a critique that I would apply equally to the liberal justices. It's a critique that I made about a similar unwillingness to consider consequences in one direction but not the other during the 14th Amendment litigation. I just think that the court, in kind of its desire to seem above the fray and, weigh in on these important questions for the ages, is ignoring what's right in front of it, which is that if you want to have an answer for the ages, that is assuming that, in those ages, in the future, your institution will continue to exist. And the Supreme Court will continue to exist as a body that can provide checks on a president. And the more that they kind of, twiddle their pens thinking through these complex issues that don't need to be resolved, the more and more likely it is that it will not persist, because practically speaking, the more likely it is that Donald Trump will be elected as the next president of the United States. And I think it feels to me, I'm sorry, I'm just ranting at this point, but it feels to me that there's a sense among the commentariat and among the sort of, rarefied world of the justices that making such a point is kind of uncouth. And maybe it is, but I do feel like there is a certain unwillingness to raise your head to look at the, the headlights of the oncoming train barreling toward you.
Roger, what are your thoughts about the oncoming train barreling toward you?
Well, a couple of things. When we had this podcast right after the argument, about 45 minutes after the argument, I would say. And so I was bleaker than I've had a chance to read the transcript. There is, as election analysts say, a pathway to some sort of acceptable outcome. I do think it is possible you could count to 5 here. You have Justice Barrett was very good, and you have if Chief Justice is sort of the swing vote. So with him, you have 5. As Ben says, he's not going to say, "Yep, affirm." He wanted the DC Circuit to engage more than it did. I think everyone is doing a disservice to what the DC Circuit really did do, which is, they didn't say there is no immunity. They say this case is easy because of these facts. And so we decide this one, but it's going to have to be case by case. And that's the way constitutional adjudication used to work. It isn't like Justice Gorsuch says, we're writing a ruling for the ages. So we're going to tell everybody, what's legal and what isn't legal in the future. That's not how the common law has ever worked. And but anyway, so I agree with Ben. You can get to 5. I agree with Quinta. You probably can't get a ruling in time to do anything with it. And I agree that, and I disagree with Jack Goldsmith that, this notion that it's political to take into account something that everyone can see in front of their faces. It's political either way. It's just like with the gerrymandering, the political gerrymandering case, where 5 Republican appointees say we mustn't. We might appear political if we were to intervene with this process. With gerrymandering that generally favors Republican candidates. You're not preserving any credibility. You're not staying out of politics. You are, in this case, you are saving this guy from a criminal indictment. And why are you doing that? It's in a federal court in, down the street from you, 3 blocks. It's not, well, I don't want to name a country where we might not trust the judicial system. But so I'm disappointed in that respect, as Quinta is. And I don't think you have to even go to, well, democracy won't exist anymore if he's elected. I think you do have to say, if he's elected, we know enough about him to say he will fire the special prosecutor, and he will direct his attorney general to dismiss this. And that, not too long ago, that would have been, 100 times worse than the Saturday Night Massacre. That would have been an impeachable offense back when there were impeachable offenses. And so, to ignore that, in fact, they've already intervened. They've prevented any possibility of getting a judgment before the inauguration, and that, so they've already intervened. That was their decision to accept cert the second time it was offered to them. So anyway, I don't buy any notion that these people are not acting politically by preventing this thing from being tried.
All right. So, from the highest-minded writing of rules for the ages to the lowest down and dirty, sleazy tabloid publishers and the lawyers who interface with them, let's go to the only game in town, the New York New York County Supreme Court, where Anna and I have been hanging out with the dust and the dirt balls, some of them human, so we've been doing the details of the case on the daily live streams. I don't want to be repetitive of that, but Anna, give us we've now had a week and a half of this nuttiness. What are your impressions of it?
Yeah, I mean, I think that I'm someone who came into this case. It's one of those cases that, we've covered Fulton County and Mar-a-Lago and the DC case in such great detail that for a long time, this case was a little bit of one that we just didn't pay as much attention to. We certainly were following it, but our coverage was just not as detailed as in the other cases. And so I came to this case very interested to see, what I would think when the evidence started being presented. I had heard criticism of the case. I also had reason to think that it was a case that seemed somewhat promising for the prosecution in other respects. So I kind of came into it with an open mind. Have been very impressed so far by what the prosecution has managed to do and the case that they are building. I want to speak about it at a pretty high level instead of getting into what we heard this week, because we do have those daily dispatches. But I think that it was a very smart move for them to put David Pecker as the first witness. He is one of the so-called dirtbags that you've described. He's the former publisher of the National Enquirer. But despite the fact that he looks like he's straight from Central Casting as this, kind of sleazy, newspaper tabloid publisher, he in fact came across as very credible, was able to really set out this whole scene and narrative that really set the scene for this prosecution and for this hush money scheme, for the falsification of the records. And then this week, some of the things that we got as well were more, kind of moves on the chessboard to go ahead and set up some of the more documents that the jury will need to make their decision. So we heard a lot of documents, witnesses yesterday in court, a guy from C-SPAN, a guy from a court reporting company, because there's some things from E. Jean Carroll's deposition that Trump sat for in October that are coming into evidence. So we got that, but then we also got this guy, Gary Farrow, who looks like a bouncer, or Ben thinks he looks like a bouncer, but he's in fact a former banker, or he's still a banker. But
he objectively looks like a bouncer.
Well, you saw him in court, so I will give you that. But he is a banker who worked at First Republic Bank, which is the bank that Michael Cohen used to make some of these used to send funds to Stormy Daniels' attorney when the hush money scheme was agreed to in terms of the Stormy Daniels matter. And I think that with Gary Farrow's testimony, it was getting a lot of documents in. He was also a fact witness as well that could testify to, for example, when Cohen was filling out these bank forms to create an account so that he could then send the funds over to Stormy Daniels. He was saying, for example, that it's not affiliated with a political candidate. He's basically made misrepresentations on these banking forms. And so that was, I think, an important part to get through, is get in these documents, get in a lot of the story of Stormy Daniels, which we didn't get with Pecker last week. The reason being that Pecker is someone who was involved in the Karen McDougal payment and the Dino Sajudin payment, but kind of, put his foot down when it came to paying Stormy Daniels. So we got in a lot of this evidence that we're going to hear from Michael Cohen about. But because of Cohen's credibility problems and the issues that have been raised in terms of the defense attacking his credibility, I think that it's very good that a lot of this corroborating evidence is coming in now, as opposed to going ahead and putting Cohen on the stand. The jury's going to kind of already have a lot of this corroborated in their mind before they hear directly from Michael Cohen, because every single witness that gets on the stand so far has indeed said things like, Michael Cohen exaggerates. Michael Cohen is always screaming. Michael Cohen is an asshole. Michael Cohen's a jerk. I mean, truly,
And one of them in a meta commentary even said, the moral of the story is nobody wants to deal with Michael Cohen.
Right, exactly. And then finally, the person who we left off with yesterday on direct examination was Keith Davidson. Again, someone who is, I expected actually to be a bit of a sleazy guy. He's this, in your mind. We heard some about him. He's an attorney in California who works with people in the entertainment business. He represented Karen McDougal and her hush money deal with AMI. He also represented Stormy Daniels when she was negotiating a deal first with AMI and then with Cohen. And, you kind of imagine in your mind that he's going to be this, kind of David Pecker type guy and just be quite the character. But in fact, he was incredibly dry, very straightforward, very kind of soft spoken, and seemed quite credible. But I think, again, with his testimony, we got more text messages. We got more of the Stormy Daniels story. Again,
we got a great band name.
We got a great band name, the Estrogen Mafia.
That's me and Anna.
Yeah, that's me, Quinta, Natalie. Maybe we can get Catherine, all the Lawfare ladies to start the Estrogen Mafia band. But so I think that was important. And then we also got as well from Davidson the fact that he testified to this idea that as he was negotiating this deal with Cohen, he talked about his understanding of the deal and why, who the clients were. That was Cohen and, Daniels and Trump, and who, would have been hurt by the story that Daniels had coming out. And at one point, he said, I understood it to be the case that Donald Trump would be hurt by this story. And so that was one of the motivations for Cohen, undertaking this deal on behalf of his client. And then also when he said that Trump would be hurt, it would be the case that the campaign would be hurt. And so I think that it's important that the prosecution is continuing to get that type of testimony into the record, in which, you have multiple people, Pecker, and then now Davidson, saying that, that these deals were being done because they believe that it related to Trump's, campaign, as opposed to his family or other reasons or reputation, that kind of thing. So yeah, I think that's my main points. Todd Blanche did struggle some on cross-examination of, for example, Gary Farrow yesterday. It didn't seem like there was a clear line of cross-examination inquiry. But at the same time, there were some weak spots with the prosecution as well yesterday. Specifically, at one point on direct examination, they were trying to elicit some information from Keith Davidson. We do not know what that information is because they never got to ask the question, but they just kept trying over and over and over again to get Keith Davidson to, testify to something that it sounds like he testified to in grand jury testimony. But they never got to it because of the objections were sustained. So yeah, Ben, what are your thoughts? I'm curious to hear your overarching thoughts as well.
Well, I'm going to give my overarching thoughts, but I'm going to do something a little bit out of order because Quinta has to drop off in a few minutes, and there are some questions in the queue. By the way, if you have questions that are not in the queue, get them in the queue in the next 6 minutes before the estimable Anna Hickey turns off the queue. But there are a few questions in the queue that I want to direct to Quinta. The first is from Linda. how might these other states' actions, Arizona, New Mexico, Michigan et al., prompt Fani Willis to act to expedite the case in Fulton County? That's partly an Anna question, partly a Quinta question. So I throw it out. Let's do the Quinta half of it before we can return to the Anna half of it after Quinta's gone.
So I don't know if there's a huge amount of overlap. I think you have Meadows, Giuliani, Jenna Ellis, and Mike Roman, which I will just say I'm very proud of myself for listing that off the top of my head. I think are at the center of the Venn diagram in terms of people who were indicted both in Arizona and in Georgia. I don't believe there is any overlap between the Georgia and the Nevada indictment or the Michigan indictment, because those are more confined to the electors within those states. And they're not, I would need to double check this to be 100% sure, but the theories on which prosecutors are bringing those cases are a lot less involved, let's say, than the RICO case. It's more sort of, falsification of documents, conspiracy to falsify documents, like impersonating a public, official, that kind of thing. So there are conspiracy elements, as you would kind of expect under the circumstances, but there's nothing quite so sprawling as the Georgia RICO charge. So I'm actually just not sure. I mean, I can imagine that Willis might, want to get things moving, but she's already well ahead of the game in terms of bringing her case to trial. The others are still moving through the process, and there are all these back and forth with defendants, trying to challenge indictments and remove cases to federal court and so on and so forth. So I would not be surprised if it was quite a while before those cases go to trial. And Willis is kind of already ahead of the game.
Although I will say that because none of those cases are as sprawling as hers, they're much less likely to get derailed by complexity, which is not to say they have no prospect of being derailed by complexity. But when Fani Willis brought that case, it was kind of unclear. And we said so in, I think, the first paragraph of our first piece about this, that whether this is, touched by genius or grossly so overly complicated that she's going to trip herself badly and really have overcharged it, is kind of an open question. And by the way, almost a year later, it's still an open question. And I don't think that's true of some of these other state cases. They're the sort of other model of how to do these things, which is much more economical, much more targeted. And there are some defense lawyers in Georgia, particularly our sometime Lawfare joiner of the show, Andrew Fleischman, who really criticized her for that and said, look, there was a simple case to bring here, and she brought a complicated case. And so I wouldn't be entirely surprised if some of those cases actually move faster than the Fulton County case for that reason. But yes, she certainly has a head start.
I think that's definitely true. Just one quick thing. It is also true that at least in the Michigan case, I think the judge has really been struggling just under the weight of how much evidence and how many defendants there are, because there are a bunch. So I think her name is Judge Simmons, has had to delay a bunch of the preliminary hearings, push them back by a couple of months just because there's so much information. So, that's may well be the case in Georgia as well, but just I think these state courts may not be prepared for sort of just the sheer volume of evidence that is going to be thrown at them in these instances.
All right, one more question for Quinta before you jump off. Anonymous attendee asks each of us, and the only one who's going to get the question now is you. Do you think it's inevitable the special counsel will seek a writ of mandamus from the 11th Circuit, reigning in Judge Cannon? And at this point, what action has she yet to take that might trigger this?
I'm going to defer to you all on this one. I will just say that I think something as dramatic as seeking a writ of mandamus is never inevitable. But I will be interested to go back and listen to this and hear what you all have to say.
All right.
And with that, I will hop off. Thank you all.
Right. We say goodbye to Quinta, and I will give you, before we actually do the questions properly, I will give you my overarching thoughts about the New York case. The first of which is that I very much agree with Anna. People have been mistakenly saying that this is a weak case. Weakness is a comment on the quality of the evidence. The quality of the evidence in this case is not weak. So the weak, like, this is a very strong case. And as the volume of material that the prosecution is putting forward mounts and mounts and mounts, the strength of the case it's becoming very clear to me, at least, that criticism is wrong. What people mean when they say what people mean when they say it's a weak case is that they think it's a trivial case, or that the case does not warrant the having been brought in this way, because the actions in question are sort of too trivial, or it took too long to bring, or Alvin Bragg's predecessor contemplated a more substantial case. The case is not weak. So that's the first thing. The second thing is I have gone back and forth over whether and to what extent it is a good thing or a bad thing for the weight of democracy to rest on the case that has the least anti-democratic overtones of the four. So this is not a purloining of classified information. This is not an attempt to overthrow the electoral system, either as seen through the Georgia RICO statute or as seen through 371 and 1512C2. But it is at the end of the day a case about falsifying business records, about to cover up payments to people you had affairs with, or who you may have had affairs with, or whatever, to keep them quiet in the run-up to an election. And it's an interesting sort of question whether that is, in the world for which we would pray, the question for which you would hold Donald Trump accountable. And I have always been a skeptic of that point, and said things like, this is the least important of the four. Notice that the least important of the four is not the same as saying that the evidence is weak. I'm beginning to think that may have been wrong, and that this is exactly the case that he should be, that I'm fine with this being the one that goes to trial before November. And the reason is because it is tawdry, because it is, because it is exactly as gross as Donald Trump, because the lead witness is somebody as disgusting as David Pecker, because you come around to a guy like Keith Davidson, who had not one but two clients in 2016 who wanted to gouge money from Donald Trump by way of keeping their stories quiet about affairs with them. And the more wholesome of them was a Playboy model. And that, by the way, Keith Davidson is way less scummy than a lot of the other people who've testified and will testify in this case. And because of all that, there is something weirdly fitting about the fact that this is the case that should rear up and bite him in the ass in the year, by the way, that he's trying to do exactly the same thing again, which is cover up a whole lot of nasty stuff, lie about a whole lot of stuff that he's done, and get elected by controlling the information stream. And that is exactly what this case is about. And having sat through it, I don't honestly look forward to hearing from Stormy Daniels or Michael Cohen, but I don't feel like this case is a irrelevancy to our current situation right now. And I think there is something very appropriate about this case. I'm reminded of the opening monologue of The Big Lebowski. Sometimes there is a man, and I'm not saying he's a brave man, or like he's a lazy man. He's certainly a lazy man. Like sometimes there's a case, and I'm not saying that it's the most important case in the world, but boy, is it a fitting case for this here moment in time. And so I will just say that's my impression as I sit through hours and hours and hours of it, that it's kind of the case he deserves. All right, let's go to audience questions. So somebody asked, by the way, am I going to be doing the Google Sheets questions? And the answer is, if people have left comments in questions in there, I will go to them, but I'm going to deal with these ones first. Just because I have them here. So Matt asks, at oral argument in the immunity case, Trump's counsel relied heavily on the argument that in drawing the line between official and non-official acts, the court should not focus on the alleged motive behind the charged conduct, because the indictment will allege in every case that the defendant had acted with corrupt intent, and that threatens to undermine the concept of immunity by requiring virtually every case to be resolved at trial. This argument has a lot of practical appeal, and the justices seemed swayed by it, but doesn't it run into a textual problem, given that the immunity is supposedly based on the Take Care Clause, and the plain text of the clause directs the president to faithfully execute the laws? Doesn't that language place the good faith of the president squarely at issue in every case where he claims to be fulfilling his duty under the Take Care Clause? So I'm going to take a quick crack at this and then turn it over to Roger and Anna for any thoughts they have on the subject. So the first thing to say about this is immunity as a general matter, at least if it's absolute immunity, always ignores intent, in the sense that, if you're talking about speech and debate clause immunity, it doesn't matter if the intent is willful. That's what distinguishes between immunity and lacking, say, the criminal intent, which is often an element of the offense. Immunity says, I was with the ambassador of Ukraine. This is literally a true story. On Saturday, I was with Ambassador Makarova, and we were going to plant sunflowers outside the Russian embassy, and a policeman said, no, you can't do that. It's illegal, which was false, by the way. And so for Ambassador Makarova to invoke her diplomatic immunity and do it anyway, she would have to willfully and intentionally defy this cop, which of course she did not do. That's immunity, right? You don't ask when you then assess, can she be prosecuted for that? Whether she did it intentionally, what her motives were. You say the nature of her position is such that U.S. criminal law cannot be enforced against her, even if she did it maliciously, defiantly, whatever motivation you say. I think that's one of the reasons why it is wrong to think about this question in the language of immunity. And by the way, the Take Care Clause is one example of why I think that's right. I think like if you're talking about immunity in the absolute sense in which we dispense it in other contexts, it's very hard to understand why somebody who takes an oath to take care that the laws be faithfully executed and that the Constitution explicitly contemplates prosecution under certain circumstances can be considered immune. So I don't actually believe that that is the basis on which the court will resolve this case, and for many reasons, one of which is the text of the Take Care Clause. Roger, Anna, do you have thoughts on this?
A small point. I mean, I don't think they were locating the immunity, source of the immunity in the Take Care Clause. They were locating it in the vesting clause, the executive vesting clause, and then plus some language in Marbury, which, but certainly you're right. I mean, a crucial thing in their case is that it has to be an objective standard. You can't get into motive. You know, in the civil case, Blassingame, the DC Circuit sort of said they developed a workaround, and they said, look, you know, we'll use this distinction between office holder and office seeker, and that's a relatively objective thing, and we don't have to look into motive. And that's something that could, if need be applied here. Possibly without disastrous results. It sounded like Alito was toying with the idea of using a totally implausible standard, where if something, the notion that this was an official act was totally implausible under the circumstances, he would allow a prosecution to go forward. I doubt that that sounded broad enough that it might help Trump. But other judges, like I think the Chief Justice, there was a lot of emphasis on what you have, and yes, certainly the Chief Justice, that what you have here is the trappings of official acts, but they're being used for a personal purpose. So it seemed to me that they were willing to go to motive, that there was no getting around it. That's what I took from the Chief Justice's discussion of bribery, that, you know, bribery doesn't, you know, appointing an ambassador is an official act. It might be a core, I don't know, executive function, but taking money to appoint a particular person is bribery, and it's clearly punishable. And you can't cut it in two and say, okay, we'll prosecute the taking of the money, but you can't mention to the jury that it's in exchange for an ambassadorship. So I think they're going to have to allow, I think they're going to break through that motive issue in some form. I hope I haven't been completely inarticulate.
Oh, we're all inarticulate most of the time when we do things live. That's part of the fun of it. All right, we're going to do some rapid fire questions. Jeff writes, what are the lunch options when covering the New York Trump trial? Are they as good as the fried grouper sandwiches down in South Florida in Fort Pierce? I will just say, I'm going to let Anna answer the grouper question. I will just say on the lunch options, they are diverse and range in quality. I was surprised at the quality of the vegan pho that I had the other day. I was less thrilled with some of the pickup sushi But the tacos that Anna and I had yesterday were, so like Lower Manhattan is, I can't compare it to the Fort Pierce grouper, but Lower Manhattan food choices are pretty hard to beat on a fast casual basis. Anna, what are your thoughts on fried grouper?
Well, I will say for lunch options in Fort Pierce during court, I think that I only ate like a bag of Cheez-Its because that's all they had in the vending machine. There's really not much around that courthouse. But there are very few foods that can beat a cold beer and the fried grouper at the Tiki Bar next to the motel in Fort Pierce, where I have stayed and Roger has had the pleasure of staying several times. But with that said, the tacos that we got in New York yesterday during lunch, Ben is right, can't really be beat. So everyone go to Los Tacos #1. I think am I right about the name, Ben?
I believe so.
Yeah. That's it. And we've also had some soup too. We had some very sad soup one day, but other than that, the lunch options have been pretty good.
Just if I can add that the Cuban coffee in Southern Florida in the Mervis near the courthouse is really to die for.
All right. Anonymous attendee, returning to your question, for each of us, do you think it is inevitable that Jack Smith will seek a writ of mandamus from the 11th Circuit, reining in Judge Cannon? And at this point, what action has she yet to take that might trigger that? Roger, you go first, since this is your bailiwick.
I think they sort of have to. I don't think you want to go to trial with this judge without trying first some other option. There's just too much, with her choosing the jury, with her writing the instructions. And I think where it could happen is they're asking for a lot of, well, I think it would be the selective and vindictive prosecution. The standards, Trump wants a lot of extra discovery, and a lot of it has to do with trying to explore selective and vindictive prosecution. And the standards against that are very, very high. I don't think they've ever been met before. And I think it will be very hard for her not to grant that. I think in her bones, she feels that this was unfair. That's why what she did the last time, where before the case started, when she appointed the special master, this unprecedented civil remedy to slow down and the prosecutors and keep them from seeing the products of a search obtained from a magistrate, approved by a magistrate. So I think that she can't resist granting some sort of discovery to pursue this selective and vindictive prosecution claim, and that might be the place to appeal.
Anna?
Yeah, I don't know. She just hasn't done anything yet. I just don't know what it is she's going to do, but I'm with Roger. I think she's going to do something that will trigger Jack Smith seeking an appeal or some type of writ of mandamus at some point. I have the same suspicion that Roger does, that I think Judge Cannon, everything that I've seen, she believes that this is an unfair prosecution, and that, I think eventually we're going to reach a point in which there is something that is appealable or mandamusable, if that is a word. But I just don't know yet what that will be.
The other place it could occur would be a motion in limine right before trial, where they bring up the, how are you going to treat the Presidential Records Act? How are you going to, are you going to let them say that's some sort of a defense to possessing, to willfully retaining national defense information, that can be, a personal record? It might come down to that.
That is what I was about to say. I think they're going to have a lot of motions in limine as this thing gets closer, and they're going to wait for her to do something outrageous on the question of the actual presentation. What arguments are you and are you not allowed to make to the jury? And that they will want a record that very clearly has her doing something lawless on those questions. And that's, I think, what they will take up. Excuse me. All right. Anonymous attendee, I'm going to try to get through all the remaining questions. Anonymous attendee asks, isn't Justice Gorsuch's desire to make a ruling for the ages legislating from the bench, or tantamount to doing it? I would say something a little bit different, but I'm not going to resist that characterization. It, of course, depends on the nature of the rule. But I would say that it reflects an extremely grandiose conception of the judicial function. And by contrast, I think I've quoted this before, when Byron White was confirmed to the court, he was back when you could just walk up to justices on the steps of the Supreme Court, which now you would not be able to do. A journalist walked up to him, and it just shows up in his New York Times obituary, by the way, and asks him, what do you think the great constitutional role of the Supreme Court is? And Byron White barked the response, to decide cases. And that reflects my much more modest understanding of the role of the Supreme Court. I've always thought it was the grouchiest and most correct thing ever said about the role of the Supreme Court. And I do think when justices start thinking that they're making rules for the ages, nothing good ever comes of that. And I'd rather that they think, got to decide a case, and think about it that way. Anonymous attendee also asks, in the event the jury convicts Trump of a felony in the New York City case, what have you seen so far that might provide the grounds for a successful appeal? Great question. Anna, I have a couple thoughts on this, but let's do yours first.
So I would need to think about what we've seen so far, but I will say that I think one thing I'm looking for as we go forward will be the charging conference and some of the rulings that come out in terms of jury instructions, just because this is, although has been articulated, the evidence is strong. There are some, unprecedented parts of this prosecution that have to do with the legal theory. And so I am very curious to see how some of the jury instructions come out, some of what his various rulings will be in that respect. So that's what I'm looking for. But Ben, I'm interested to hear what your thoughts are on what we've seen so far.
Yes, so I also think that the legal theory will be the source of the appeal, or the principal source of the appeal. And I think a lot will turn on what Justice Merchan instructs the jury as to what they have to find regarding the so-called object offenses. Do they have to all agree about which object offense they find that is satisfied here? At what level does it or the intent to commit it have to be proven? And I think he will likely be pretty conservative on that, at least if he's smart. Because honestly, the last thing you want is to get a conviction reversed on that ground. But I do think that's where the complexity / vulnerability of the case probably lies. Okay, we have 5 more minutes and 5 more questions. So I'm going to race through them, try to do a minute a question. Sebastian asks, if Trump had recorded the checks accurately, either as Ms. Daniels' biography or National Enquirer advertisement, would there still be a case in New York? And the answer to that is no. If he had recorded it accurately, or if the Trump organization had, there would not have been falsification of business records with intent to do anything, and therefore there would not be a crime. Keith asks, I have not seen any coverage on any repercussions to the National Enquirer following David Pecker's admissions on the stand. Maybe the Tiger Woods, etc. stuff does not technically constitute extortion, but it sure seems like the Ted Cruz stories would definitely be libel. Is it just statutes of limitations issues or a lack of political incentive for Ted Cruz? I think the answer to that question is yes. Anna, what do you think?
On the latter part of the Ted Cruz?
As in, why are there no there are no legal ramifications for, basically making up that Ted Cruz's dad. So with that, by the way, you can't libel the dead. I'm not sure if Ted Cruz's father is alive or not, but you would have to imagine that he wanted to bring a case. You would also have to imagine in the case of Tiger Woods that Tiger Woods would want to pursue something in which the result of which would be that all these negative stories about him would come out.
Yeah, I think that's right.
But it is also, there are going to be statute of limitations issues there as well. Okay, next question from Suzanne. How can it still be an unsolved mystery whether Trump actually had affairs with Stormy Daniels and Karen McDougal? Over the years, what evidence has come to light to suggest they either did or did not have affairs with Trump? And did Pecker, Davidson, and Cohen appear to believe the women or Trump? So quick answer to this. First of all, I don't think it is much of a mystery. I don't think everybody in the case of McDougal and Stormy Daniels, and particularly McDougal, believed her. There was internal correspondence within AMI that the story was very likely true, but she didn't have any evidence of it. There is some evidence emerging at trial that it was true, which is when Trump was first presented with the Karen McDougal story, he didn't say, who the fuck is Karen McDougal? I've never heard of her. He said, Karen is a nice girl. And he inquires after her a few times how she's doing under the deal. So he's clearly aware of her.
Well, and there also was testimony from Rona Graff, who was Trump's executive assistant, and they elicited testimony from her that said that she, put these contacts into the Trump organization contacts, and then they showed documents that showed Stormy and then Stormy Daniels' phone number, and then Karen McDougal and Karen McDougal's contact information. So Trump certainly had their contact information. There's also this sighting of Stormy Daniels at Trump Tower that came out through testimony this week as well. So there's, in addition to what Ben said, a number of things that suggest that Trump was, at least knew these women. And it doesn't seem like there's much dispute about, other than, what he has said publicly previously. But amongst other witnesses, there doesn't seem to be much dispute that what they alleged in terms of a romantic or sexual relationship was true.
But it doesn't make any difference legally, does it?
No, not at all, except in the extremely limited sense that a jury who thought Trump was subject to extortion based on false information might be a hell of a lot more sympathetic to a panicked response than a jury that thought that he was trying to pay off people he'd had affairs with in order to juice an election. All right, we got 2 more questions. one of them substantive and one of them procedural. Tony asks, in the minutia of federalism, under what legal authorities does the U.S. Secret Service have to direct things in a state courthouse? For example, jurors going through U.S. Secret Service security just seems intimidating. Holding press public in courtroom to wait for Trump to exit, etc. So the answer is the authority is very simple. They are charged with the protection of former office holders at that level. And to the extent that they have that authority, that is under the Supremacy Clause, the law of the land, the supreme law of the land, and the state courts have to accommodate them. I will say that the Secret Service behavior in this case, as a lot of you know from my projection work at the Russian embassy, I am a big fan of the Secret Service. I think their behavior in this case has been exemplary. They've had a very low profile. It has not been, it's not into the court, and I think they've done a terrific. A couple of weeks ago, Ben said to send feedback about coverage to his email address, and then he'd read it on air. And he read the email on air, but when I tried to send something to that account, it bounced. The contact information here seems to be quite out of date, and he gives a very out of date website that I should probably take down. So let me give you my email again, benjamin.wittes@lawfaremedia.org. And that's benjamin.wittes@lawfaremedia.org. And people should feel free to email me. If there's a very large volume of emails, I might not respond to every single one of them, but I do try. And by the way, if you're, I just warn people when I give out private information, you have no reasonable expectation of privacy in abusing strangers. And if you send me abusive emails, I do screenshot them and post them to social media with your email address visible. That's just a warning to everybody in general. You're free to email me, but I have the unreviewable discretion to decide whether to make your emails public. So be careful. And by the way, you should be careful. That's true of your interactions with other people too, that some of them just don't say it. We are going to leave it there because Lawfare Live, Trump Trials and Tribulations begins and ends on time within a margin of error. Thank you to Quinta Jurecic, who's not here anymore. Thank you to Roger Parloff in the Sconce studio. Thank you to Anna Bauer in the room about 20 feet away from me. Thank you to Anna Hickey, who is running all of this and making it possible. And thank you to everybody who has joined us and made us and been patient with us as we resolve and continue to work through certain tech glitches that arise when we try to do these things.